It's just, you have to understand that there's always immigration risk.
My job as a litigator is to tear apart records and find mistakes.
Yeah, but like, just for me to understand, so, and you have to explain it to me.
If I have that situation, let's say I have a client, I get the RFE, do my best to answer the RFE, get the denial. Now I have a couple of options, right? So I get this denial and USCIS says I have, 33 days to file a motion to reopen / appeal. I talk to you. I understand maybe there's an option to litigate. So first step, should I, as the attorney or the client / applicant, should I file a motion to reopen to get this reconsidered? Or should I, and I want to go forward, right? I want to keep fighting. Or should I talk to somebody like you and go straight to federal court? What are the things I should be thinking about there?
I think your timeline, when you go to the AAO, your timeline's a little bit out of your hands. You have to file within a short timeline, but your answer is not going to be something that is a known to you. Whereas if you go to federal court, there's it's fairly strict, at least in the beginning, where you're going to get some type of response from the government within 60 days of filing a complaint. The difficulty also is you say, well, I want to go to the AAO and then I want to sue. Well, you have to understand that you may have a more defensible decision issued by the agency than you would if you have an error on your denial from a director decision. They overlooked evidence. They conflated step 1 and step 2. If it's an O1A and EB1A, something I see now all the time, where you submit evidence and they're like, that's not evidence. And they're really making a merits determination. I think going to the AAO, which is the traditional way immigration attorneys practice, is wrong. It's a waste of your money and it's a waste of your time. Because this is the other thing. And this is, I think, going back to the theme I've been driving on about increasing denials. So they'll definitely take your money now and issue you a really fast decision. They'll issue you a really boilerplate RFE because they need time. Then the decision is going to mirror that RFE, no matter what you present them. And they'll do like 2 sentences talking about what you submitted in response to the RFE. And you're stuck after 30 days with a really good case for an EB1A or an O1A. And you have a really just boilerplate conclusory decision with no analysis. I've seen that in the last 2 months more than I saw in the last year. So in my view, the only way they're going to stop this practice of taking money and denying is federal court. They're going to have to get a nasty decision or just talk and retrain their officers to do a better job, because I'm seeing a lot, almost like verbatim. You see it, David, right? It's the verbatim. It has to be objective evidence. It's like, wait a minute.
Yeah.
Why is this not
objective evidence? And then they tell you why it's not objective.
Yeah.
No, I definitely get that. So that's okay. So let's move on to the next step. You've convinced me to forget the AAO, the motions to reopen / reconsider. Yeah. Okay. I want to hire you to help me. Let's call it an EB1A because the stakes are higher. It's a green card. The threshold is higher anyways, the evidentiary threshold. Let's say my client's an Indian national, so can't really benefit from an EB2 NAW anyways. So yeah. EB1A, stakes are high. How do you approach this lawsuit if this is really just subjective anyways? It's just one adjudicator's opinion of whether or not my client is extraordinary. So what do you do? Yeah. How do you frame the issues? How do you win? How do you win these cases?
Yeah. I think so. The cases are going to be strong if you have a strong record. And you can point to the criterion that they've met, or that they, and especially if they've met, let's say 2 and there's 1 outstanding, it's not about re-arguing the case. That's not your strategy. It's not mine. It should never be yours. It shouldn't be like, well, I disagree with what he said about the merits, like a Kazarian merits. You don't, those cases, unless you're going to take Kazarian on itself, or it was so outside the lines and you are the starting center for the Lakers, like, no. But, you know, you want to look to statements that they made that contravene the policy manual or their own AAO decisions in the past. Meaning, you know, sometimes they'll say, they'll totally reject expert letters as non-relevant when the policy manual tells you that they're probative. You know, that's like a no-no. They can't just do that for no reason, especially from acclaimed people in the field of endeavor. The other one I see all the time is
they'll say they're not objective. You know,
Yeah.
you know this person too well, so they're not objective.
But yet the reason we know each other so well is that we're one of the few people in the world who do this type of science, right? Or this type of art. The other thing I see, you know, the best case for me as a litigator is where they wholesale overlook a critical piece of evidence. You didn't submit scholarly articles that you wrote. And you're like, no, I did. It's right here, Exhibit R. You know, and that's great. Bad for you, good for me. So those types of things where I can point to something that anyone can, you know, I don't need any type of background in immigration to understand that you submitted X and they told you you didn't. A federal judge gets that, and that case will settle.